Hello, my name is Joshua Gilliland, one of the founding attorneys of the Legal Geeks. The following was recorded at San Diego Comic-Con on July 24th, 2025. It is our Jurassic Park Liability for Dinosaur Attacks Never Goes Extinct panel. We had so much fun putting this panel together and a great time at Comic-Con. I hope you enjoy the recording.
We'll do some introductions right now while we're waiting. First up, Magistrate Judge Stacie Beckerman from Portland.
Yes.
Well, there are a lot of Magistrate Judge Stan Boone fans. Unfortunately, he had his flight canceled and he's unable to be here. A little chaos theory that happened, but law finds a way, and we're going to go ahead. We also have Kathy Steinman from the Senior Christine. Micheal Dennis, who and I know on the first day of law school today.
Yeah, it's just like, Josh always says, well, Mike knows where all the bodies are buried, which isn't true at all. There's only one body. So we're getting it. But that's like 1998.
Yeah, it's a long time ago and far away in Sacramento. So let's begin. All right, we are here to talk about Jurassic Park. We'll hit on Jurassic World. We'll talk about Camp Cretaceous. We won't really get into the chaos theory, but stay tuned for that. And there's lots of great animation for Jurassic Park as well. So, for the panelists, what is your favorite species of dinosaur? Michael.
I'm an Ankylosaurus kind of guy.
Okay.
A little throwback to coming as Dr. Hammond, the older person in the script that enjoy. It's like a giant armadillo, I guess. You still see walking around today, so I'm kind of fond of that one.
Judge Beckerman.
The Velociraptor because they're clever.
Yeah. I always liked the Triceratops. They just seemed like kind of gentle giants, like kind of fearsome but cool.
Christine.
So I don't have a favorite species, but as for individual dinosaurs, it's a tie between Bumpy and Cindy.
Kelly.
Dinosaurs.
Triceratops for me. So, there's no wrong answer, unless you pick something that's not a dinosaur. All right, so let's talk about wrongful death at Jurassic Park. The first movie is a wrongful death case. You have an employee get eaten. Just imagine being corporate counsel. That would be an unpleasant afternoon. I'm not sure what it's like for a lawyer for a zoo, but that would be concerning. Now, there are lots of deaths that happen in the first movie and the following movies, but just focusing on the first film, we have our corporate spy who definitely has some issues of contributory negligence. The horror story of that poor lawyer just doing his job is killed like that. That's the sin of the movie. He was the true hero, and he's martyred by a T-Rex. Now, Judge Boone thought there could be comparative negligence, but I think it's the kids with the flashlight that signal the T-Rex. If those meddling children hadn't gone out a flashlight, we wouldn't have a movie. It would have just been really slow. We have Sam Jackson dying in Love Again, which is a motif with his movie characters. Losing an arm is also a motif. And he theoretically just assumed the risk of going out knowing that there were velociraptors running around. Now, you have the doctor who, look at the other movies in the animated series, it's like, is there a good guy or a bad guy? It's really hard to tell, but is he the one who's responsible for all this? And at the end of the day, it's like you're working at a place with dinosaurs that can eat people. There's going to be some assumption of this. But this raises the issue, Kathy, can you patent dinosaur DNA?
So in the sequel to Jurassic Park: The Lost World, Peter Ludlow, who is the new CEO of InGen, he makes a statement. He says an extinct animal has, that they brought back to life, has no rights. and it exists because we made it. We patented it. We own it. In the original movie, if we go to the next slide, in the original movie, they explained how they brought the dinosaurs back. And what they did was they were able to create the dinosaurs by using DNA technology. They sequenced DNA that they obtained from blood in a preserved mosquito and then used frog DNA to fill in the gaps in the DNA sequence. And then what happens, so the next slide after that, sorry, 2 slides. And these are all screenshots from the tutorial that they show in the movie that explains how they created the dinosaurs. And I see we have a Mr. DNA right here. That is an amazing comment. We did not plan that.
So great.
But the U.S. Supreme Court has actually commented on the issue of whether or not you can patent naturally occurring things. And in 1980, in a case called Diamond versus Chopper Body, they said that a person who invents or discovers any new useful manufacture or composition of matter can patent. Sorry, I can't read my notes. And so in that case, there was a man by the name of Chopper Body. I don't think I'm pronouncing that correctly. He sought a patent for a human-made, genetically engineered bacterium that could break down crude oil to help clean up oil spills. And the court said that that was patentable because it was something that was not naturally occurring. He created it, so he could patent it, even though the organism itself was, quote-unquote, natural. And then we get to 2013, in another case, the Supreme Court ruled, the case is Association for Molecular Pathology versus Myriad Genetics. And in that case, you have Myriad Genetics who sequenced the BRCA1 and BRCA2 genes. And for those of you that don't know what that is, it's a very important gene to women because if there are mutations in that gene, that indicates that you have a higher likelihood for breast cancer. And so Myriad Genetics sequenced the gene, and then they invented some diagnostic tools to determine if there were mutations in the gene. And they tried to patent it, and the court said they were not allowed to patent it because the sequence itself was a naturally occurring gene. So what we have to ask in this situation is whether or not the DNA sequence, if we can go to the slide with the DNA sequence, oh, we're on that one, sorry, that one. So is this DNA sequence naturally occurring? And now you have to remember, they got it from dinosaur blood, and then they put in frog DNA. So who thinks that's naturally occurring? See a couple hands out there. And who thinks that is man-made? So the court hasn't ruled on this, but I think the rest of you are correct. I think I would make the argument that it was man-made because putting together those two things isn't naturally occurring, because I don't think a dinosaur and a frog have made it yet. And then the other thing I wanted to point out too, to add to my argument is, all right, any bio majors out there? I was a bio major. I know she's my sister. All right, who knows what is different or unusual about this DNA sequence? I'll give you a hint. It's at the top of the screen. You may not be able to see it. All right, there's a B. Bio majors. Is B a naturally occurring DNA? I see a lot of head shaking no. That's correct. So it's not what we were taught when I was a bio major. So you have A, C, T, and G are your nucleotides for DNA. B is not a naturally occurring one. But according to Google, B can stand for complementary DNA or cDNA, which is actually a man-made sequence. So if we think the graphic designers for this movie were bio majors, they might have actually indicated to us that this was not naturally occurring, it was man-made, and therefore patentable. But maybe they just made a mistake.
Thank you, Kathy, for the room captains. Could you turn off the one panel of lights? That'd be great. And for the panelists, lean up on the mics, please.
Okay.
So, Michael, let's talk about causation. Does causation exist in the air?
Well, first I'd like to welcome everybody to jury duty tonight. The issue of causation is a jury question. You get called for jury duty and it's not a criminal case. Most likely, you're going to be having to decide, did what the defendant do cause the injury? And we're going to focus on actual and proximate cause, because that's what has to be proved. We're going to point a lot of fingers tonight about who had a duty to do what and was that duty breached, but causation is what comes down to. First, you have actual causation. This is referred to as but for. You're asking, Mike, what is a but for? I'll tell you, it is to poop with. And this will be my last panel on the legal geeks for that. But for causation is what a lot of people refer to as the butterfly effect. You say, well, but for this happening. But for a harness, you wouldn't have fallen into the raptor bin. But for the raptor bin being electronic instead of hand cranked, you wouldn't have fallen in. But for the designer designing for raptors, you wouldn't have done it. You go back until you get to that butterfly in Africa that flapped its wings. So the courts have done is that at some point we have to cut that off, and what they do is they cut it off with foreseeability. And that's where we get to proximate cause. And the trouble I have when I decided to tackle this is that I'm at Comic-Con where everybody in this room thinks everything is foreseeable. They're like, well, maybe not in this verse, but on Earth 5, this could have happened. And you got to believe I'm not going to leave Comic-Con without talking about something super. So we have intervening and superseding causation. Rarely is it just plaintiff and defendant. There's usually somebody else involved in it. And the question is, that other person's participation, was it interceding cause that just contributed to it, or was it a superseding cause, meaning it cuts off liability? And the example normally used is the car accident, where the defendant hits the victim ends up going to the hospital, and the doctor commits malpractice. The defendant says, hey, that doctor's malpractice should cut off my liability, I shouldn't be responsible. And the law has decided, no, that malpractice was foreseeable, you're responsible for everything, you're the proximate cause. I think it's kind of unfair to doctors to say that your malpractice is foreseeable. Therefore, what you do, we're going to hold that other guy accountable for it. So, I was hoping someone would come as Dodson and I could point at them, but everyone, if you're a plaintiff attorney, you want to point as many people as possible so you have as many pockets to get a good result for your client. If you're a defense attorney, you want to do the same thing, so you have someone else that's actually going to help pay for the defense of it. So you're my jury, and because of the jury question, the judges on the panel can't give a decision on this. They decide stuff about duty and breach. But let's throw some scenarios at you. So we have on the next slide, the estate of McDougal is going to claim, Nedry, you are the actual and proximate cause. Nedry, of course, is going to argue, what do you mean? I'm not the one that turned off the power to everything. I actually kept the security on to the Raptors. It was Hammond who decided to turn off everything, and that's how the Raptors escaped. He's the actual causation. And besides, it's foreseeable that on this island, where a hurricane's coming, the power might go out. No backup generator, kind of thing. So could he get off? Probably not, because there's a timing issue. And that Nedry's actions occurred before Hammond turned it off. So he can't really claim, well, somebody else did it first. And the same thing comes when the engine tries to do a defense of, well, Nedry did everything. Nedry did it before, so more than likely it's not a superseding, but it is contributory towards it. So that's something after this panel you'll have to, if you want to decide later and debate about it with your fellow Comic-Coners, for each person that died in this, who actually caused it, who was the proximate cause, and was that something that could cut off the chain of liability? And if you believe in one thing, engine warned everybody before anybody died. If I was going to address the jury, ladies and gentlemen of the jury, you were warned to cover your butts. Did anybody cover their butts? No. They are all responsible. Contributory negligence should be off the hook. And Josh touched on this earlier. Did Dr. Malcolm actually kill our beloved attorney? He was the one that decided to step in, pick the flares out, and lead them towards the outhouse. As we all know, apparently, T-Rexes can't see unless it's moving. Although the thing has a nose the size of a Volkswagen, you disappear if you're not moving. It becomes smelly or something like that. He's the one that threw it. He's the one that led to the outhouse being knocked over. That caused our beloved attorney to move. and that's what led to it. Dr. Malcolm caused the death of our attorney, not Injun. We got a jury instruction for that. And this is actually a real one. That's right, the jury. If you're in an emergency situation, you're not held to the same standard as somebody that has time to reflect on the proper course of action to take. So Dr. Malcolm does have the defense of, I was in an emergency situation, there's a T-Rex. I did what I thought was right in this situation, although maybe I should have thrown the flares onto the other side of the road where somebody was not trying to hide.
Judge Beckerman, can you insure Jurassic Park?
Sure. Good evening, geeks. Obviously, liability insurance is important for any business that's offering an inherently dangerous activity. And it's generally available for businesses like zoos or amusement parks, or maybe a better analogy is like a shark cave diving or something. But the problem is it's expensive, of course. So a lot of companies that offer dangerous activities, so like Disney, for example, is self-insured. The only potential limitation for Jurassic Park being insured is you can't insure illegal activities. That's seen as bad policy because you are promoting crimes. And so you could not, Jurassic Park likely could not get coverage for any unauthorized dinosaur cloning or illegal tours like the Dinosaur. But what if John Hammond shopped around and tried to get liability coverage for Jurassic Park and nobody would insure Jurassic Park? Could the government step in, or could courts step in and force insurance companies to insure Jurassic Park? And the short answer is no. Generally, neither governments nor courts can force an insurance company to enter into a contract with a party. And so states, of course, try to encourage insurance companies to offer coverage, much like California is doing now with respect to offering incentives to insurers to provide homeowners policy in high-risk fire areas. But of course, if insurance companies do offer a policy and offer worry-free liability insurance for Jurassic Park, and then they were to refuse to pay for any harm caused that's covered by the policy, that's when the courts step in and force the insurance company to pay, and that happens all the time.
So, what could possibly go wrong? Christine, let's talk about disloyal employees.
Sure. There seems to be a pattern of betrayal in these films, and it often involves a company's workers not just turning on it, but stealing valuable company assets. And for the sake of expedience here, I'm just going to assume that U.S. and California law apply and that jurisdiction and venue are proper in U.S. courts. So let's go over the elements that either InGen or Biosyn, respectively, would need to show to establish a civil claim for breach of the duty of loyalty. The first is a relationship giving rise to the duty of loyalty. The California state courts generally hold that an employer-employee relationship is sufficient. So as to Ramsey Cole, it seems reasonably clear that he's an employee. He's described as communications or head of communications for Biosyn. As to Ian Malcolm, a little bit less clear, but Sattler describes him as Biosyn's in-house philosopher, and at one point Dodgson purports to fire him, so maybe he is hired as an employee. And then you have Dennis Nedry. The source material gives some pretty strong hints that he's probably meant to be an independent contractor. He refers to bidding for the job, and another character refers to Nedry's people in Cambridge, so he appears to be affiliated with a separate company. But even assuming that he is an independent contractor, that doesn't necessarily get him out of trouble. He might still owe a fiduciary duty of loyalty if he also qualifies as an agent of InGen. So an agent is someone who represents another in dealing with third parties. So just briefly, the test is, if Nedry had been authorized by InGen to deal with third parties on its behalf and setting up the computer system, InGen still retained the right to control Nedry's activities. He might be in an agent-principal relationship. Those are more examples of the factual questions that Michael referenced that are likely to be disputed, and you might need a jury to decide them. So the second thing you need is the person who owes a duty must have knowingly acted against the employer's interests or knowingly acted on behalf of a party whose interests were adverse to the employer. So for Nedry, he's being paid to steal valuable dinosaur embryos. The the personal property of InGen and deliver them to Biosyn, InGen's competitor, he also creates a massive safety risk, which ultimately leads to property damage, physical injury, and death when he fiddles with the computer and security systems to try to cover up his wrongdoing. For Malcolm, he discloses to Sattler that the locusts are part of a larger project called Hexapod Allies, tells her where to find the lab, gives her a device that will allow her physical access to the restricted lab so they can steal a locust DNA sample. And finally, as to Ramsey, he points out the location of the elevators to the sublevels that require special clearance and gives Grant and Sattler 30 minutes alone, knowing and expecting that they will steal a DNA sample. All of this is either against InGen's or Biosyn's interests, respectively. And then finally, there must be damages approximately caused by the breach. Yes. Moving on. So the factual wrinkle of interest here is the nature of the property being stolen, specifically the live embryos and DNA samples. The physical embodiment of those things likely carries valuable information about InGen and Biosyn's research that they've invested a lot of time and effort into developing. However, to the extent that the duty of loyalty claim is based on misappropriation of confidential information, the company is going to have to look at whether the trade secret law might supersede the duty of loyalty claim. So for example, the California Trade Secret Misappropriation Act is a statute that allows recovery of damages for injury caused by the misappropriation of trade secrets, but it's the exclusive remedy for conduct that falls within its terms. And many courts have interpreted CUTSA to broadly supersede claims based on misappropriation of any information that's claimed to be confidential, even if it doesn't actually meet the definition of a trade secret. So if the genetic information that's contained within the embryos and the DNA samples is a trade secret, or it otherwise is confidential information, this aspect of Nedry's and Malcolm's and Cole's wrongdoing would likely have to be addressed under trade secret law or some other theory that is not superseded. So for Dennis, however, there may still be a way to allege a duty of loyalty claim based on all of the other ways that he has acted against InGen's interests, namely being deceptive and enabling a major security breach that endangers the physical safety of everyone on the island, including himself. Finally, you might ask, aren't Cole and Malcolm just doing their civic duty by disclosing Biosyn's wrongdoing? And it is true that there are various state and federal laws that protect whistleblowers from retaliation by their employers for disclosing what they reasonably believe to be violations of the law in various contexts. That doesn't mean, however, that they can facilitate the theft of locust DNA samples, although the federal law does provide a narrow, limited immunity for disclosures to government officials or attorneys solely for the purpose of reporting or investigating a suspected violation of the law. So ultimately, the takeaway here is that Soyona Santos has the right idea. You should nurture loyalty and treat your workers well.
So Mike, let's take a trip through the 70s, and I thought it's a good idea to have lions and wild animals for entertainment.
Just, like we're talking about this panel, people are like, oh, that sounds silly, that sounds stupid. This is Irvine, California, about an hour and a half north of here. I grew up in the town right next door. This is a real place where you could drive among the lions. When you look closely at the picture, you see you've got somebody not driving their own lane. You have a window open for the lady to pet the lions. More than likely, it could have been me in the back of that station wagon without a seatbelt, and the driver was probably smoking. My parents actually got warnings about be on the lookout for an escaped hippo. That happened twice. They eventually got shut down because the lions and elephants were escaping and mauling people and guests. So, yep, these are issues that actually have real life application.
And I will add, watch the documentary Roar about making a movie, and it's Tippy Hedren from The Birds, her husband. They had 70 lions, and they were trying to make this movie. Over 100 people got bit by lions, tigers. It's insane to watch. It's on Peacock. Enjoy your Friday night.
And by the way, Life Story is still available in Florida if anybody wants to go. All right. We have to stick up for our own here. If you look at that quote, it's quoted all the time from Shakespeare, and it's probably the highest compliment you could actually give to an attorney. What it says is if we want to start a rebellion, we want to overthrow the powers that be and install chaos and get rid of civilization, first thing we have to do is get rid of the guardians of the law, the gatekeepers that keep us civilized and keep rules in place, and that is attorneys. So it's kind of a high compliment that the first named character that gets killed off is the blood-sucking attorney, Guerrero. So, that compliment immediately gets taken away. There's a couple memorable moments in the movie. When you first see the dinosaurs, welcome to Jurassic Park. The trembling glass of water. And then, the attorney getting eaten on the outhouse. Thanks, Spielberg, for that. And if you must know, if you go to the next slide, there's an exclusive SDCC toy from 2022 is Outhouse Chaos. And you too can reenact the famous scene of the attorney and the outhouse getting eaten. Your children can play with it. You can now do it. So I felt it was my duty to stick up for attorneys in this case and to see what's he really so bad. And because we're talking about an outhouse, I'm going to talk about duty. My second poop joke, thank you. On it, there's a lot of duties that are involved with this attorney. Where I'm not going to talk about was he denied a rest break because he was on his break apparently when the T-Rex ate him. I'm not going to talk about his duty of competence to his actual clients when he says, we're going to make so much money. It's like, what do you mean we? They hired you, they're going to make a lot of money. What I'm really going to focus on is his duty of competence. Because this is the first time anybody's ever inspected a safari filled with dinosaurs. And when you don't have the knowledge as an attorney, you're either supposed to find an attorney that does, associate with an attorney that does, or gain the knowledge. And that's what most attorneys do. They don't want to turn away cases. In this case, he has to become knowledgeable. And what we do as attorneys is hire experts. So that's what Juro is supposed to do. When he's coming to inspect it, is assemble a team so he can get the knowledge to inform if this park is safe. He brings a rock star. That's what he gets complained of. He gets one person, and he's a chaos statistician. And I looked into chaos theory, and we're back to the butterfly effect. And his basic rule is saying we can't predict anything over a long period of time because there's too many variables. That's what chaos theory comes down to. Okay, you're not helpful at all. Bring in Dr. Grant, who spends the whole movie going, wow, they run in herds. Wow, they're not actually cold-blooded. Wow, look at this. The most beneficial thing he says is humans and dinosaurs have been separated for millions of years. We have no idea to expect. Okay, you're useless too. Then we have Dr. Sadler, a paleobiologist. A botanist. What's the botanist going to tell you about safety of dinosaurs and keeping your guests safe or how to run an amusement park? I love her character. I think she's the most kick-ass character in the movie. When she puts Hammond in his place about sexism, about who's going to go rescue somebody, she's awesome. She doesn't know how to run an amusement park. She does not know how to run a safari or a counter at this point. So, yeah, he brings Dr. Malcolm, who Stephen assured me he was going to cosplay as, so I didn't. I had to come as Dr. Hammond instead. I can do a couple more buttons over the course of the panel, but that's not going to happen. So, the only person that has any experience is McDougall, who came over from the game park in Africa, and his advice is, put the raptors down. His other solution was, let's engage the lysine effect so all the dinosaurs go no coma and die. Nobody listens to him. So I would argue that, in spite of how I want to stick up for Juro, he fails his duty of competence because he did not get the knowledge necessary to actually fight the dinosaurs.
Fun fact, my brother named his son Ian.
Now, I'm going to assume we're in California, and the other big issue people have with our beloved attorney is when things get tough, when you have to go, according to the other characters. He went running off and abandoned the children. So did he have an actual duty to protect these kids? California, you have generally no duty to protect somebody else. There is an exception, and that's if you have a special relationship. And I think the law's kind of creepy and says, you have a special relationship to protect a child, when like, special relationship with a child? Gross. But it's when you're in a sort of a custodial capacity and the child is looking to you for their safety and care. You can voluntarily undertake this, So that's kind of the question is, did he have a duty to these kids? Did they look to him for their protection? And it's quite obvious they did. I mean, they kept saying over and over again in panicked voices, he left us, he left us. Of course, his version is, they wanted to sit with Dr. Grant. I don't know how they ended up in my car to begin with. And the parents, I'm not a teacher, I'm not a coach, the parents entrusted them to their grandfather for their safety, not me. If I was prosecuting, I would definitely say he voluntarily did it when he told him to put back, or told Timmy to put back the night vision goggles that are expensive. He asserted himself into the role of the authority figure and the adult, and that's when he took on the custodial relationship and he was responsible for protecting those kids. Naturally, he would have been worthless. You saw that T-Rex comes through the sunroof of the Jeep. Those kids held back with their little arms that T-Rex. They would have been protecting him. And then when the car gets squished, Timmy was safe. Timmy's small. Guerrero would have been crushed by that car. He would have been useless, but he still had that. I believe he still had that duty to protect him.
Or he could have said, put the flashlight down.
On it. And it just, to leave you can't spell indeed without engine. I believe they're probably looking for a new current counsel, so inquire with him.
All right, Stephen, let's talk about Camp Cretaceous.
Yeah, it sounds like there's some Camp Cretaceous fans here. That's great. So for those of you who don't know, Camp Cretaceous is a Netflix animated series. It kind of takes place concurrently with the 2015 Jurassic World film. So while Claire and Owen are fighting off the Indominus Rex, so are these 6 teenagers, except without weapons, without adults, and without shoes with traction. And when the island gets evacuated at the end of the film, the children are left behind to their own devices on the island, and then ensues 7 seasons of them versus dinosaurs. So can the parents or the children sue Jurassic Park for their injuries? It's pretty obvious that yes, there's like negligence, the breach of duty to care for these children, negligent infliction of emotional distress for watching your friends be almost eaten by dinosaurs, breach of contract because the parents think they're sending their kids to a fun summer camp when in fact it's like a dinosaur-themed Hunger Games. I don't know, if it's a product liability, if there's strict liability, if the dinosaurs are products, there might be liability there, and also false imprisonment because the children are trapped on this island, they're not able to go anywhere. But the real question is whether the parents are able to sue if they signed a release of claims and liability waiver. And so for all of us who have ever done anything fun, you know that you have to sign a release of liability to do that thing. It's a contractual allocation of risk. So, and it's perfectly legal. You can say, I assume the risk of injury if you let me participate in your fun thing. And so chances are that parents of these children signed a liability waiver, and courts will generally enforce them if they are clear and unambiguous, if they are specific about the risks that you're going to face, they don't violate public policy, and if you knowingly signed the waiver. Now, if I was representing the parents, I would say that this is not any liability waiver that they signed is not enforceable. We can sue because, first of all, those waivers will only excuse conduct that is based on negligence, simple negligence. Someone does an oopsie, you get hurt, you can assume that risk, that's fine. But if there's some sort of gross negligence involved where there's reckless disregard for someone's safety, or if there's intentional conduct, then that is not within the scope of your release of liability. And of course, I would say that exposing children to huge building-sized human-eating machines is grossly negligent. That is not within the scope of their waiver. And also, that any sort of release might be against public policy because the government has an interest in protecting children, as we were just talking about. And so a court might be inclined to excuse a waiver of liability if the children's safety is involved. So if I was representing the parents, I think we'd have a pretty clear shot. Any waiver of liability is not worth the amber it was written on. We're good to go.
So let's talk about the incident. Christine, can you help us?
So I just want to be clear from the outset that InGen and Mizrahi Global are facing massive potential exposure regardless of the procedures used to pursue recovery. But this question asks whether the procedural device of a class action is an available means for large numbers of injured people to seek recovery. So a class action is a lawsuit that's been brought by one or more plaintiffs on behalf of a larger group, but it's not always going to be appropriate to certify a class just because you have a lot of injured people. The parties seeking certification have to satisfy certain requirements. And since state class action procedures can vary, I'm going to use federal law for this discussion. So a party seeking to certify a class has to satisfy all of the prerequisites in Rule 23A of the Federal Rules of Civil Procedure. First, the class must be so numerous that joinder of all the members is impracticable. And according to the film, the live count on the day of the incident is 22,216. So numerosity is probably not going to be a contested issue. Second, there must be common questions of law or facts. This requires you to look closely at the elements that plaintiffs must prove in order to establish their claims. So to survive as a class claim, the claim has to depend on a common contention, which must be capable of class-wide resolution, meaning that determination of that contention's truth or falsity will resolve an issue that is central to the validity of the claim in one stroke. So for example, you might try something like, did defendants breach a duty of care by failing to evacuate all park visitors sooner upon learning of the asset containment failure? If you went with something like this, the class definition might look something like, all visitors present in the park during the time when the Indominus was not secured in her paddock. So the decision to concentrate the visitors in one area and not immediately ferry them off the island was one that affected all class members, even if reasonable minds might differ about whether the company actually did enough to conform to the applicable standard of care. An up or down answer would resolve the issue for the entire class. Next, the claims and defenses of the plaintiff who's going to serve as the class representative must be typical of the claims and defenses of the class. The test is whether other members have the same or similar injury, whether the action is based on conduct which is not unique to the named plaintiff, and whether other class members have been injured by the same course of conduct. And here you might start to get a little pushback from defense counsel. Although this slow evacuation is common to all plaintiffs, the extent of their injuries is likely to be different. I say this because in the chaotic aftermath of the escape, there were some fairly atypical chains of events, such as a park employee getting tossed around by different flying animals only to be eaten by a mosasaurus. So if you had a lot of examples like that, where the injuries really stem from an unusual series of events, it might be harder to find a typical representative. Finally, the person who represents the class has to be able to fairly and adequately protect the interest of the class members. But since we don't know anything about this hypothetical class representative or their counsel, I'm just going to spot plaintiffs as requirements. If the plaintiffs can get past Rule 23A, they still have to satisfy at least one of the subdivisions of Rule 23B. So class actions for damages typically proceed under 23B3, which means the party seeking certification has to show not just that there are common issues, but that common questions of law or fact predominate. And the reason is that when common issues predominate, a class action is likely to save time, effort, and expense compared to individual lawsuits. But if they don't, a class action probably wouldn't be that much more efficient. An individual question is going to be one where the evidence is going to be different from class member to class member, whereas a common question is going to be one that can be resolved based on generalized class-wide proof. So the predominance inquiry asks whether the common issues are more prevalent or more important than the individual issues. So this is often where the fight is and where it's probably likely to be here. There's plenty of theories we all can imagine, many of which have been named here, under which InGen, Mizrahi Corporation, or their employees or vendors might possibly be liable to individual plaintiffs. But defendants are going to want to argue there are too many individualized issues for these theories. So for the negligence theories, they're going to argue there's too many individualized defenses, right? What about people who contribute to their injuries through their own negligence, like failing to heed warning signs, or deliberately antagonizing the dinosaurs, or failing to heed evacuation notices? They're also going to want to argue intervening causes. What about people whose injuries have been caused by subsequent unpredictable actions of another park goer? And they're also going to want to say that individualized damage calculations are going to prove overwhelming. With such disparate injuries, it will be hard to come up with a way to measure damages that would apply to all 22,216 people. So counsel for plaintiffs really needs to think hard about whether it's worth it to invest a whole lot of money in trying to certify a class if the evidence is such that this motion for certification would probably be defensible. And if they decide it's not worth the risk, there's still other ways they can try to gain efficiencies. They could move under the Multi-District Litigation Act for a transfer of all of the civil actions that are pending in different courts to a single district for consolidated or coordinated pretrial proceedings. If there's common questions of facts, then the transfer would be convenient and promote judicial efficiency. On the flip side, if defense counsel is really taking a hard look at the company's future and decides this ship is going down no matter what we do, they might want to explore whether they can use the bankruptcy procedures to resolve any of these claims, clear up these debts, and salvage what they can of the company. And although there's been some debate about the extent to which mass personal injury claims can or should be resolved through the bankruptcy mechanism, one thing the district court can clearly do is that in its discretion, it could at least order that all these cases have to be tried in the same district. So in the end, though, no matter what procedures are used, these are going to be some rough days ahead for these companies.
All right, due to time, I want all the panelists to kick into gear like they're being chased by a T-Rex. So, the issue of, hey, Jurassic Park has signs, is that adequate? The answer is probably not. While helpful, the idea of like, hey, I put up a sign to wear the T-Rex, that's only going to get so far. And you're going to have a sympathetic plaintiff if someone's eaten by a raptor or gorged by another dinosaur. So, helpful, but not enough. Still have the signs up, but we're still going to need a really big Judge Beckerman, can you tase dinosaurs?
Josh, let me ask our jury. Raise your hand if you believe it is illegal to tase a T-Rex. All right, so raise your hand if you think it is legal to tase a T-Rex.
Who doesn't want to be dinner?
Okay. Well, you know, we all spent a small fortune on law school to learn that it depends. Yeah. Of course, and I think what's in your heads is that of course it's okay if it's in self-defense. So if a T-Rex were to return to San Diego and we found the T-Rex outside the convention center, if we had a reasonable belief that the T-Rex posed an imminent threat of death or serious bodily injury, we would be entitled to self-defense. And that's well settled. And so that self-defense applies unless you either provoke or intentionally attract the dinosaur. So in the original movie, when the employees tased the dinosaur that attacked Joffrey, that was likely valid self-defense. But in Rebirth, where they intentionally attracted dinosaurs to retrieve their genetic information, it might be a closer call. But what about all of you with ill-behaved dogs like mine who might try the shock collar or the shock fence in your yard? Is that legal? Have you asked yourself that question? Generally, those tools are legal unless they rise to the level of animal cruelty. Every state has an animal cruelty law, and sometimes a shock collar or a similar device can rise to the level of torture. So if you're using them for training, generally not torture. But there is a well-publicized case where moviegoers sued the elephant trainers behind the movie Water for Elephants, and they claimed that they attended the movie thinking that the elephants had been treated humanely, and then they were surprised to learn that they had used shock collars on the elephants. And so they sued in federal court up in LA, and the court dismissed the case. But so generally, tasing animals is not a great idea, but in a small voltage, it is allowed under the law. I want to add one note, and that is that if a species is threatened or endangered, the Endangered Species Act has protected those species at a higher level of criminality for people who take or harass or harm a species that's listed as endangered or threatened. But I will note that today, both the Endangered Species Act as well as the lawyers, federal lawyers who enforce it, are in danger of extinction. So we may or may not be discussing the Endangered Species Act by the next con.
Kathy, can you bring a dinosaur to the United States?
So it depends. In the Lost World, InGen brings into the U.S. via cargo ship 2 T-Rex, a papa and a baby. And specifically, they bring it into downtown San Diego. We'll get into that in a moment. So is that legal? Well, as Stacie mentioned, the Endangered Species Act might be applicable here. And specifically, Section 9A of the Endangered Species Act says that, among other things, it is unlawful to import into or export any such endangered species into the U.S. or take them on the high seas, which they go and move. But dinosaurs are not on the endangered species list. Duh, they're extinct. But what if they were resurrected? And actually, the news we've seen recently that there have been attempts to resurrect the woolly mammoth. They apparently have resurrected a dire wolf. I don't know. But if they were resurrected, it is possible that they could be categorized as endangered species and potentially protected by the Endangered Species Act. But technology always outpaces the law, so it would probably take some time to do that. But how do you bring? We're in San Diego, right, home of the world-famous San Diego Zoo. How do they bring animals in? Well, there's a lot of paperwork, a lot of regulations, and a lot of permits. So what are some of those regulations? We go back to this one. So this is a screenshot from the movie where they bring the animals into the Port of San Diego. The Port of San Diego, you can walk outside and look east, you'll see the port. That ain't it. That was not filmed here. But you have to look at, and there's a lot of different agencies, maybe, we'll see what happens in the next few years, that regulate the different kinds of, have different regulations about what you can bring into the U.S. And so I first looked at the USDA, and they have a lot of regulations about turtles and terrapins and things like that. Obviously, there's not going to be any regulations addressing dinosaurs. But according to my go-to dinosaur expert, Dino Dan from Nick Jr., dinosaurs are actually more closely related to birds. And so there are a ton of regulations about bringing birds into the U.S. And it has to do with how many you're bringing in. Are they going to be pets or are they going to be poultry? And so there's a lot of different things that you have to look at. So InGen would have had to file all kinds of paperwork to get permits to even bring these in. And there's no indication they did that in the movie. And in fact, it seems like they did that sort of in secret, which how would they have built this huge amphitheater in secret, bringing these big dinosaurs into, if you've seen the movie, you know, spoiler alert, the T-Rex breaks out of the cargo ship and rampages through, not downtown San Diego. But there's also, because we're in San Diego, I wanted to look at some local regulations as well. And so the municipal code here says that no person shall bring into or maintain, and it goes through a bunch of things that you can't bring in, but wild animals. So I would say that dinosaurs would fall under that. But there are some exceptions. So the first exception is for a legally operated zoo or circus. I think it's arguable whether or not this park that they're creating in San Diego would be legally operated since nobody knew about it. They didn't get the proper permit to begin with to even build it. And the second exception is service animals.
My emotional support to you.
I don't know about you, but I don't think dinosaurs are service animals. And in fact, under the ADA, the only types of animals that can qualify as service animals are dogs and miniature horses. So I don't think any of these exceptions would apply as well. So I don't think they follow the proper procedures to bring these dinosaurs into San Diego.
Mr. DNA is on the slide. Just really briefly, I know we're kind of here at the end, but this is all we've been talking about here is de-extinction. That's an actual term of like the scientific effort to bring animals that have gone extinct back to life. And legal scholars are already thinking about the legal frameworks that could or should apply to de-extincted creatures. And we've already talked a little about personal injury and the complexities about causation and who would be responsible exactly. The Endangered Species Act we've talked about a little bit, although that's a little nuanced because never before has the ESA been applied to animals that have been created by humans. So for example, I think of glowfish. like that are the little clownfish that have the glowing DNA from jellyfish, if those escaped into the natural habitat, we wouldn't think of those as an endangered species just because there's small numbers of them. So that's a weirdly complex question too. The National Environmental Policy Act has complexities because dinosaurs are going to be both an invasive species because they don't exist in any ecosystem, so they're going to like knock out other species from the ecosystem's biodiversity, but they're also maybe endangered, and the law treats those things really differently. So that's really difficult to pin down. And then genetically modified organisms, the regulation of them is all over the place. So we've been talking so much about whether laws could apply to the dinosaurs. Maybe we should talk about whether they should. That's the upshot here.
So I do a lot of boating, and I did want to spring during the Jurassic Park rebirth a lot. But one of the issues from Fallen Kingdom is you have a cargo ship go from Costa Rica to Humboldt County, California in the span of 24 hours. That's not possible. That's over 4,000 miles, and to do that in 24 hours would mean that the ship is traveling at about 181.5 miles per hour, which is like 157 knots. The average speed of a cargo ship is 24 knots. That trip should take 179 days. So that's a long time to be a stowaway with dinosaurs. So I'm cool with cloning dinosaurs, but not shipping being abused by like that. So just remember that law finds a way. And I want to thank you all for your time here, like at 1 minute. So like there's no time for questions. But the guys in the back are high-fiving because lawyers until time. But you can follow us on Instagram and Threads and TikTok at the Legal Geeks. We're going to start blogging more. And thank you. Enjoy the rest of Comic-Con.